All right, we're talking dagga, cannabis, and all the other host of names that this goes by. And while the court judgment to decriminalise the private use of cannabis was a victory for lobbyists of the plant, it appears that it might have also opened doors for legitimate concern. And just recently, a Pretoria-based trucking company dismissed 300 of its employees for testing positive for using cannabis. And yesterday, human rights groups, elders and traditionalists and clinical experts, they gathered at a community indaba to discuss what the legalisation and decriminalisation of dagga actually means for South Africans. And to help us unpack this further, I'm joined here in studio by David Letsoalo, who's acting head of the Institute for Dispute Resolution in Africa. Thanks so much for coming through, David.
Thank you.
David, let's start here. We had the court judgment, but I don't think we necessarily understand as South Africans what that means. So perhaps let's start there by just outlining for us the parameters with regard to that judgment.
That's true, and I think you've got the whole conception right, because there's a lot of excitement around this, and even the lobbyists, and most of them, I think, are overexcited about the whole thing. And I don't think it's a victory for them. It's a minor victory, if not a half victory. The court did not decide on the wholesale decriminalisation or legalisation of the plant, marijuana, cannabis, or dagga, as you might choose to call it. The court was asked to deal with the Section 14 aspect of it, which is the private and use of the plant in one's private home. In other words, one can grow it and use it in his or her private home. So it excludes many other aspects, including to grow and sell, the whole trading in dagga and marijuana. So it's a very, very limited aspect. Where we stand at the moment in terms of the recent judgment, which was delivered on the 18th of September, is that people who are interested in using it can grow and use it in their private homes. Anything that goes into the social space, in the public space, then is going to be limited in terms of the various limitations of the Constitution.
And David, these are some of the concerns that are being expressed right now. For example, this case of the trucking company and, drivers testing positive. So now there seems to be a bit of conflict with the law, as per that judgment and what it meant. So people, some would say, acting recklessly, taking the plant, the herb, and then going to work, and employers seemingly, in this instance, not too happy about it. But, how do you juxtapose the two?
First is the whole issue of the use of power, more especially as somebody who's in authority or being an employer, that to actually say to the employees that here I'm in charge. Two, it also reveals a lack of education about the ruling, the recent ruling, which actually attests to my case when I'm saying that the judgment hasn't opened up the floodgates for everyone to say, I can use it the way I want. The whole issue relates to the private use of the plant in one's private home.
But if I use it in my private home and I go to work and my employer tests me and it obviously shows up within a specified period, I mean, isn't it my right to puff in the privacy of my home?
See, that's the challenge of looking at judgments and also the legislative position in a limited way. And I think from there you can actually add to our jurisprudence to say if you say one can use the plant in their private home, what about the amount of time that the effects will be in someone's body? But then the whole issue should be looked at holistically. It's not really about that. There are a lot of issues involved, and I think that is why we can expect in the coming future, in the coming weeks or so, continuous mobilization, lobbying by interested groups, demonstrations and so on, to push the boundaries in terms of allowing people or individuals to use it. Look at the whole issue that it's not only used for recreation. So the hype is about recreation. The marijuana or cannabis is used for various other things. The medicinal value of it, the spiritual value of it, and the religious aspect. And on that, I want to even punctuate on the aspect that when we talk about religion, we seem to restrict it to the Rastafarian community, of course, which is enshrined and protected in terms of Section 31 and 30 of the Constitution, but also in terms of African spirituality. And we learned yesterday also that in terms of African leadership, traditional leadership, that marijuana or dagga, it becomes an integral part, depending on where you stand, in terms of exercising your spirituality and various aspects.
So I think you'll agree with me that there's still a lot of education that needs to be done, even at this elementary stage, at this one judgment, and who knows what will transpire going forward.
Exactly.
But that indaba that you are talking about, was there anything, particularly noteworthy that came out of that?
A lot of aspects. Pertinent to it is the fact that we need a lot of education about this judgment, that it didn't really offer much. Number two, the dagga or the use of dagga is still seen as something that is not allowed in terms of the Drugs and Drugs Trafficking Act. So that is why the employers can actually, test people, because they know that the decision, the ruling by Deputy Chief Justice Zondo, did not touch on all these other aspects, only touched on one, that limited aspect of private use in one's private home. So that's it. But the rest, the status quo remains in terms of the fact that it remains a crime to smoke or use dagga in terms of the provisions of the Drugs and Trafficking Act.
Very interesting. So for these 300 employees who could, by the way, be breadwinners in their families, if you were to represent them legally or give them advice, what would you say to them?
Well, it comes back to the whole issue of a violation of various, human rights, in terms of, for instance, human dignity. I mean, to just be picked up, to be tested and like that. And of course, the employers would invoke the limitation clause, as is always the case with our laws, where individual interests are infringed, then people invoke the limitation clause. And two, also, your right to your body integrity, as it were. I mean, if somebody just, say, come, let's test you. Now, from yesterday's deliberations, the Rastafarian community is actually complaining, legitimately so, to say that even in the public, they're just picked up because they've got dreadlocks, they look in a different way, that you are suited to be having dagga in your possession. You are picked up in front of your children, in front of your relatives, and so on and so on, to say, come, let's test you, let's search you, body search you, even without a warrant. All those kind of things, they infringe on various other human rights aspects. So our role as an institute, research institute, is to make sure that we participate in this debate, because the ruling enjoined the parliament or government to engage in a legislative process to come with legislation that would regulate the use of marijuana, not generally, but only in terms of the private use in the home. So
David,
that is the problem.
Please take us along with you as you learn, educate us along with you. Thank you so much for coming through.
We really thank you, and we need this space to educate the nation.
Absolutely.
Thank you so much.
Well, thank you so much to David Letsoalo, and he is, of course, acting head of the Institute for Dispute Resolution in Africa. And as you heard, much education still needs to be done with regard to that ruling. September, it's already November, but clearly we still don't understand. But we'll park it there for the moment. Right now, time for the latest news with Leanne.